My name is Victoria Hahn. I'm an associate at Goldberg Segalla, lover of puns, and member of the New York State Bar Association. These videos will take a closer look at the social media platform Instagram. It's common for attorneys to counsel their clients about what they post on social media. Many people have heard or read a story about a case that was lost because the client posted one too many things online. But we hear a lot less often about what attorneys or law firms should or should not be posting. When it comes to legal ethics issues that arise on Instagram, it is important not to be left in the dark room. For the most part, the basic principles behind the legal ethics involved did not change. Instead, with the rise of social media platforms like Instagram, the line for crossing some of the ethical guidelines and model rules has just been a bit blurred. In 2017, the New York State Bar Association published an update to their social media ethics guidelines of the commercial and federal litigation section of the New York State Bar Association. Although these might not apply to all areas of law in New York State, they are still a solid foundation for understanding how social media, and Instagram in particular, may be used by lawyers and law firms, as well as some ethical principles that attorneys would do well to follow. The ethical concerns as they pertain to Instagram accounts can be broken down into a number of larger categories. First, communication with an opposing party. Instagram allows users to control the privacy settings of their own page. Some users may choose to keep their Instagram profile open for the public to see. This means that you don't have to follow that person in order to see the content they post. Usually, this content is not restricted, regardless of whether the individual is represented. On the other hand, some users may choose a higher form of privacy on their accounts. This means that unless you follow them, you will not be able to see any of the content they post. That's where Guideline 4B comes in. Guideline 4B states that lawyers can communicate with unrepresented parties and request permission to follow that person on Instagram in order to view restricted content on that person's profile. However, the attorney should probably refrain from commenting on the opposing party's posts or sending any kind of private message. However, if you do choose to follow someone on Instagram, be sure your account has your proper information. This should include your full name and an accurate profile photo. A user's name on Instagram is what's known as a handle and shows up whenever they comment, post, or follow someone. Your handle is basically a username and always follows an @ symbol. Usually, people don't use their full names for this. If a party is represented, you should follow the traditional ethics rules and refrain from any contact. This would include hitting that follow button to request following any represented party. Number 2, communication with an existing or prospective client and attorney-client privilege. Be careful that your posts do not include any information that would otherwise be considered attorney-client privilege. To this effect, be wary of any photos you post that are behind the scenes, like prepping for a case or a big trial. Even if you are posting information that you believe is anonymous and has no identifying information about the client, you may still be in violation of legal ethics rules. In one case, a public defender had his license suspended for blogging anonymously about his clients. When it comes to posting client confidences, it's better to steer clear. Another facet of this level of communication is for prospective clients. Be sure that any of your posts on Instagram, either the photos or stories themselves or the captions and commentary, do not provide any reasonable expectation that an attorney-client relationship has been formed. This also goes for comments and direct messages. If you do decide to comment on someone's post with legal advice, be sure to include a disclaimer or some type of other cautionary language. Rule 3A prohibits lawyers from providing specific legal advice on social media. Number 3, don't go out of state. Even if you are an expert in a specific area of law in New York, that doesn't mean you can give someone from Pennsylvania legal advice about that subject. While you shouldn't be dealing out legal advice on Instagram, you should still be careful when talking to someone from outside your jurisdiction. Social media generally can make it pretty difficult to know where the people you're communicating to are from or where they reside. This is especially true for Instagram. Other social media networks have a specific user-generated profile that lists people's hometowns, where they went to school, where they work, and current cities. Instagram, on the other hand, is once again more minimalistic in its user profiles. Unless a user deliberately puts their location in their profile, which is limited to just 150 characters, then you probably won't know where that person is from. Number 4, solicitation of clients. Instagram allows users to tag themselves or check in to specific locations and businesses. To use this feature, the poster does not have to be at that location when they are posting. This can be a helpful tool for users to get the attention of a company or business. However, lawyers and law firms should probably avoid tagging themselves at specific locations to grab the attention of that place or entity. Otherwise, they may be considered to be attempting to solicit clients. Guideline 3B prohibits attorneys from using social media to solicit clients. Solicitation refers to advertisements directed to or targeted at a specific recipient or group of recipients, their family members, or legal representatives for the primary purpose of retention of the lawyer or the law firm. So, it is okay if you or your firm post advertisements on Instagram in an attempt to drum up some business. However, you should not tag or include any hashtags or location tags that would make the post specifically targeted at one person or entity. This same concept would also extend to tagging individual users in posts or comments or direct messaging another user. This brings me to number 5, attorney advertising. The Ethics Guideline 2A states a lawyer's social media profile that is used only for personal purposes is not subject to attorney advertising and solicitation rules. However, a social media profile, posting, or blog a lawyer primarily uses for the purpose of the retention of the lawyer or his firm is subject to such rules. Hybrid accounts may need to comply with attorney advertising and solicitation rules if used for the primary purpose, the retention of the lawyer or his law firm. These communications do not typically include communication to other lawyers or existing clients. However, according to the NYRPC, Section 1A, attorney advertising would include any public or private communication. In order to be considered attorney advertising, the communication must be for the primary purpose of retention of the lawyer or law firm services. Regardless, Guideline 3B explicitly prohibits any public solicitation through live communication. This includes solicitation through posting an Instagram story or direct messaging, which could be considered a form of instant messaging. However, the laws surrounding attorney advertising are still new and developing. Attorneys should use caution when posting anything on social media. If in doubt, include a disclaimer that is consistent with Model Rule 7. If you are advertising services through Instagram and include the proper disclaimer, you are still limited in certain areas. You cannot post anything that directly states or infers that you are a specialist in an area of law unless you have the credentials required to be considered a specialist in that area. You are still responsible for monitoring and removing content that others post on your account that violate ethics rules. This includes any comments, endorsements, and/or recommendations. There is an exception to this if you or your firm is contacted by a potential client looking to retain your services or seeking legal advice. You may respond to these, but be sure to keep in mind the other ethical considerations we already discussed. One last thing to keep in mind while using Instagram. While New York State has yet to issue an ethics opinion on conflicting client values, the guidelines advise that attorneys and firms should make sure that what they post does not conflict with their clients' values. Any conflicting opinion could be imputed to the lawyer's firm and be considered adverse to the client's interests and needs.